All right, good morning and welcome for another year of ESELA with Bricker and Eckler. We're excited to have everybody here this morning to talk about the child find and evaluation process. This is our first installment of ESELA this year. Please, just a couple logistic things. Please make sure you are filling out the survey at the end that was included in your email to give us feedback to help continue to make this a productive session in time for everyone. You will then receive your certificate on the back end of that, as well as register for subsequent sessions. And the link will be the same, but we still ask that you register. But just so you know that the link is the same, it's a series setup link for that purpose. Today we have Katy Osborn from Bricker and Eckler. She's going to do the first part, and I believe transition later on to Laura Anthony, who is going to take us home. So I'll turn it over to Katy and she can get started. If you have any questions, please, if you can put them in the chat box. Aaron Curtis, another SST consultant, will be kind of managing that. Katy, it's all yours.
Okay, sounds good. Good morning, everyone. It's Friday, so that's good. It's the end of the week. I'm closing up a hectic week here. I'm sure you all are as well. We're hearing a lot about the challenges, I think, of this year that this year has brought. So we're here to help you, give you some information that hopefully will help you address some of those challenges. So I'm with the education practice group of Bricker and Eckler, work out of our Dayton office. I am actually working from home today. I live in Springfield, kind of halfway between Dayton and Columbus, if you're familiar with the area. So I get over to Columbus quite a bit as well. I've been with Bricker for 5 years now, and I've been practicing, let's see, this is my 18th year of practice, primarily focused on education throughout the bulk of my career, certainly over the last 5 years since I joined Bricker. And I just give you a little bit of my background. I advise school districts regularly on, day-to-day operations, matters of policy, but I have a focus in civil rights. I have an interest in special ed and Title IX, and so I practice in that space pretty frequently, actually probably most of the time. Just keep in mind as we go, and you'll probably hear this from all of my colleagues who are going to present throughout this ESELA series, that we're school focused. We deal with school administrators, we advise school districts, and typically get involved when things are more hostile or more complicated than your typical situation. So if you sense any sort of bias coming from us, that's our perspective. So we're looking at things through the lens that we're accustomed to seeing. So this is the first training in this series for this year. We're going to be doing a variety of topics. You'll hear from several of my other colleagues throughout the year if you do the rest of the series. This is the first one. We're also going to be covering IEPs. I believe that one's next month, probably with Melissa Bondi. 504, I'm going to be doing that one in December, so I'll be back then. Confidentiality, procedural safeguards, that one's coming up, and then conflict management. So keep those in mind as you're thinking about signing up for some of our future sessions, that those topics will be covered as well. So before we jump into the substance, just a couple of disclaimers. We're not giving you legal advice today. This is not intended to provide specific legal advice. This is going to be a general overview of the law. I'm going to, talk about broad topics and talk about, your obligations under the law. If you have a specific question about something that's going on in your district dealing with a specific child, you should certainly reach out to your own legal counsel to address those facts. But that being said, if you have a general question, feel free to pop it in the chat, as Steve said, and we will try to address those as time permits. If we are your legal counsel and you have a specific question, of course, we would encourage you to reach out to us offline so that we can have a more detailed discussion about the situation and help you with that. So general questions, hypotheticals, perfectly fine, and you can put those in the Q&A. I'll try to keep an eye on that. I've got the slides on a screen off to the side, so if you see me looking away, it's because I'm looking over there trying to make sure I've got the right slides up, and I'll try to keep an eye on the chat as well.
Katy, if it's easier, we can let you know if there's questions that come in.
Okay, sure. Yeah, that would be fine. Thank you. All right, so what we're going to talk about today is what we call the road to eligibility. So we're going to talk about child find, and then the referral and evaluation process. Those are the topics I'm going to cover this morning. And then after that, we'll take a break. And then Laura Anthony is going to come in and she is going to delve into the details on eligibility determinations. And then I hear that she might be reciting some poetry at the end of this, so you'll have to stay tuned. I'll tell her that I gave a spoiler alert, but I think she's going to do that today, so that's always fun. All right, so let's pop in. We're going to talk about child find. So what is it? Child find is the term used to describe a school district's legal obligation imposed under the IDEA on schools to find children. It is exactly what it sounds like, to find children who may be disabled and in need of special education services. This is an affirmative duty. Schools have the affirmative duty to identify, locate, and evaluate students who they suspect may have a disability and a need for special education because of that disability. And that means, because it's an affirmative duty, that it's not enough to wait until you hear, a parent inquiry or a parent referral for evaluation. It's an affirmative duty on the school district to seek out and find those students. And that means that you should maintain a system of notices and outreach efforts and staff training and have referral procedures that are designed to determine when there are reasonable grounds to suspect a disability. It's something you want to make sure all your folks are trained on and knowledgeable about, because the suspicion of a disability can arise, throughout your educational setting. And so you need to make sure that when someone has that reasonable grounds to suspect a disability, that they know what they need to do with that information. So where do you find them? They can be anywhere. They can be under a rock. They can be locked in a basement. I certainly hope not. They can be not coming to school. So it may be students that you don't see. You still have an affirmative duty toward these students, even if they're not regularly in your building. They can be at a home in your district. They can be homeless. They could be attending school, of course, in your district. It also applies to students who are attending school in your buildings, but who are doing well academically, who are, maybe not emotionally, but they're doing well academically. That doesn't necessarily mean that they don't have a disability and require the need for special education services. Children who are incarcerated, children who are hospitalized, wards of the state. On incarcerated students, there is a joint Dear Colleague letter issued in December of 2014 that stated that absent a specific exception, all IDEA protections apply to incarcerated students and their parents. So OSEP advised that an agency can't assume that a student who enters a jail or a juvenile detention facility is not a student with a disability just because they haven't been previously identified. So that child find obligation extends to students who are in juvenile detention or incarcerated in jail. And local education agencies should work with individuals who are most likely to come into contact with students in the juvenile justice system to identify students suspected of having a disability and ensure that a timely referral for evaluation is made. That's a direct quote right out of the Dear Colleague letter. Implications for, the district of responsibility, the district of residence, the student remains their responsibility if they're in the custody of youth services, if they're, or if they're wards of the state, both for child find and for services. So keep that in mind. And this has been a major focus of advocacy groups and a hot topic for the Department of Education and the Department of Justice. The obligation extends to students who attend private schools. So don't rule out students with disabilities just because they're in private schools. Mobile children, migrant children, children who are homeschooled, and children who may eventually need the district programs, so preschoolers, and children who are absent from school, especially if they're absent due to medical or psychological reasons. So, truancy, incarceration, hospitalization, suicide, drug treatment, those are the kinds of things that are often overlooked. And students who are not attending because of mental health issues and mental health conditions, social phobias, anxiety and depression, PTSD as a result of bullying. I already mentioned academic achievers, students who are advancing from grade to grade, but still have a disability and are in need of special education, who may not be, necessarily obvious when you're just looking at their grades and their ability to advance. So districts have that obligation to identify, locate, and evaluate those students who reside in their district, even if they attend a private school elsewhere. And there's also a duty to identify, locate, and evaluate students who reside elsewhere and attend a private school in your district. So that goes both directions. So who has the child find obligation in that situation? Is it the district of residence or the district of service? And the answer is both. So what that means is that there might be a time when a parent can request an evaluation from both districts, and technically they would be entitled to that. There is another dear colleague letter where OSEP advised that a district cannot refuse to evaluate a student who resides in the district on the basis of the child's, independent parental placement in a private school outside the district's boundaries. And when it says, while the department generally discourages parents from requesting evaluations from two different LEAs, if a parent chooses to request evaluations from both the district of residence and the district of service, both LEAs are required to conduct that evaluation. And if the parent disagrees with both, they can request an IEE. So keep that in mind, that just because the student is dealing with two different districts doesn't mean that you don't have your own independent obligation, regardless of what they ask of the other district. So school districts are required to provide interventions to resolve any concerns for students who are performing below grade level. So this could be a regular education student, but who requires interventions. But note again that those academic achievers, that doesn't excuse you from your child find obligation. So providing interventions, but if you suspect a disability, you need to go ahead and go through your consent process to pursue an evaluation of that child. And then, as I mentioned, schools are required to undertake child find with respect to public and private school students as well. So schools are responsible for additional child find for students attending private school, students who are enrolled in the Autism or John Peterson scholarship programs, a determination of whether or not those children will receive special education services. Non-public schools are covered in one of our later topics, but I just wanted to mention that.
Katie, we do have a question in the chat.
Okay.
If a student has a history of irregular attendance and hence has not had opportunities to receive appropriate instruction over the years, would that student still be considered to qualify for special ed services?
So not necessarily. They may or may not. It's going to depend on the circumstances. So in the if you suspect a disability, but at the end of the ETR process, when we get all the way to reviewing the data and making the determination, if the reason is lack of appropriate instruction, that disqualifies them for services. So because you don't know. So not necessarily, but it does not absolve you of your child find obligation. Okay. All right, so I sort of touched on this before, but just keep in mind and always remember that child find is an affirmative obligation. You can't wait for parents to come in with a referral. You can't, if you have a suspicion that the child might have a disability that affects the child's educational performance, you need to affirmatively seek out the consent to do that evaluation. Now, there is a case where a district was held not to have violated their child find duty in rejecting a parent's request to evaluate a student. If just because a parent makes a referral doesn't mean you absolutely have to do the evaluation, right? Because you can make the determination that you don't suspect a disability. Of course, you'll document that in a prior written notice. But this is a Columbus City School District case from 2014, where a district was found not to have violated child find in rejecting the parent's request. In this case, it was a request for an evaluation of a student for emotional disturbance. And the district had no reason to suspect that the child's poor grades were the result of a disability. And in that case, tying into the question you just gave me, was that the student had 30 absences and 17 tardy attendances that school year. And the teachers testified in the hearing that the child was capable of doing the work. So in that case, they found that the district did not violate their child find obligation. When there is a child find obligation, the remedy is comp ed. So if you fail to conduct child find,
Katie, I believe we're having connection issues.
can you
Yeah,
all
looks
hear
like
me?
there we go. You're back.
Okay, sorry about that. I don't know what happened. Everybody froze. So if the district fails to conduct its child find or fails to refer a student when they have that reasonable suspicion of a disability, the remedy is comp ed. So the student's family, will receive compensatory services. It could also include the district covering the cost of a private placement by the parent. So it can be very costly. When a student with disabilities is in an out-of-state residential facility and there's an allegation that the child find obligation was missed, that does not absolve the district from the obligation either. Specific case on that, this is a case out of Connecticut from 2009, but a parent had informed the school district that the child was placed in a psychiatric hospital. There was a prior diagnosis of depression. The child was taking antidepressants and medications. And the school tried to argue that once that student was privately placed in this residential facility, and in this case, the residential facility was in Utah and the district was in Connecticut, that cut off their obligation for child find. And the court rejected that and said the district failed in their child find obligation. So let's see, it looks like we've got another question.
We have a couple questions, yes.
Okay. All right, the school district cannot use interventions to unnecessarily delay an evaluation. Can we hold that one? Because I'm going to talk about that later. And then does a meeting have to be had with the parent to refuse to evaluate, or can you just send a PRO1? I mean, I don't think there's an affirmative duty to gather people, but I do think that when you're looking at dispute resolution, which is really part of the big picture, it's always better if you can have a face-to-face meeting and explain what the reasoning is, listen to the perspective of the parent. But I don't know of an affirmative obligation to have a sit-down face-to-face meeting. If they request it and you don't suspect a disability, you can document that in a PRO1. Okay. All right, so let's talk about referrals, timing for an evaluation. And the important thing here is really to know what is a referral, because that's what triggers your timeline. So know what constitutes a referral and don't ignore it. And that will help keep you out of trouble. So there is no requirement that a referral be in writing. If you have a district policy that says that there's going to be a specific form used for a referral and you try to draw the line in the sand on that, you're going to lose. It can't be required to be in writing. It can't be required to be on a specific form. And it's not required to be submitted to a specific staff member. And that's why it's really important to train your staff and people who aren't necessarily just your ISs and your special ed folks. Your general ed teachers need to understand this obligation, because if a parent reaches out to a general education teacher and says, I think my child needs testing, that's a referral. So keep that in mind. When students are attending school in your district, child find is typically achieved when the parent or educator refers a student. So it's usually when a student's academic, social, emotional, or behavioral struggles prompt a suspicion of disability. But again, because it's at that affirmative duty, you can't rely solely on the parent to refer the student with the suspected disability. And instead, educators who work with the student, so we're talking about, all educators, including your general education teachers, have to take action to process a referral anytime there's a suspicion of that disability that adversely affects the child's educational performance, and as a result, may require the child to require special education. So a parent of a child can initiate the request, or the district can initiate the request for the initial evaluation. So once a referral for the initial evaluation is requested, whether it's by the parent or by someone within your own district, the district is responsible for processing that referral. Within 30 days, you have a choice. You either get consent from the mom and dad or parent or guardian, or you issue a prior written notice. And when you issue that prior written notice, if you decide that you are not going to evaluate that child because you don't suspect a disability, that needs to be documented on this prior written notice. So if you don't suspect a disability, you don't have to evaluate, and you would document it there on that form. So this really highlights the point that a request for an evaluation doesn't automatically trigger the school district's obligation to test. There still has to be that suspicion of disability, right? So, a suspicion of disability and a need for special education services. So if you refuse, though, to conduct the evaluation of the student, and then later, you've documented it, you send it out on the PRO1, we don't suspect a disability, we're not going to conduct an evaluation. And then the student is subject to discipline under the Student Code of Conduct. There is a risk that that student may be considered suspected disabled, which would entitle them to the same disciplinary safeguards that a student who is identified would have. So just keep that in mind, that once that door is open, if you refuse to evaluate, those disciplinary protections may apply. And we are going to be talking about student discipline in one of our later sessions where we'll go into that in a lot more detail. But just keep that in mind, that refusal does trigger disciplinary protections.
Katie, we have a few questions about who can make referrals. Can it be a probation officer, a doctor, an outside agency? Do you have to wait for the parent to confirm that they also want a referral?
Anyone can make a referral. So if anyone brings it to the attention of your staff member that there is a suspicion of disability, that is when you have to determine whether or not you think there is a suspicion of disability, if you haven't already done that. So you would consider that, yes. Okay, so to conduct an evaluation, as I'm sure you know, you have to have consent. And consent is defined in the federal regulations. There's a specific definition that says the parent has been fully informed of all information relevant to the activity for which consent is sought. So anything relevant to the evaluation that you are proposing to conduct. That information has to be given to the parent in their native language. Now that's common sense, right? We're not going to communicate something to someone in a language they don't speak because they can't really be informed if they don't understand it. It can also be communicated through another mode of communication, whatever is understandable by the parent. And then the parent has to understand and agree in writing. So it does have to be written. Referral doesn't have to be written. Consent does have to be written. They have to agree in writing to the carrying out of that activity. And it needs to be detailed. It needs to describe the activity. It needs to list the records that are going to be provided in connection with the evaluations. And it is going to be, to be written who we're going to release the records to and what the activities are going to be. The parent also has to understand, I think I'm on the wrong slide, sorry about that. The parent also has to understand that consent is voluntary and that it can be revoked. Once we give consent, that doesn't mean that we always consent. We can change our mind. The parent can change their mind and revoke that consent. And of course, we do have the PRO5 parent consent form for evaluation. So I did want to go back. I'm sorry, I skipped the slide. Someone even asked this question. So someone asked the question about the delay of the timeframes. So you cannot use interventions to unnecessarily delay the evaluation. So what that means is that if you get a referral and you've got your 30 days to get consent and then 60 days to get the evaluation done, Appropriate interventions should be implemented during that 60-day time frame, but it doesn't change your deadlines. That's what that means. You can't say, well, we got this referral, but we're not going to evaluate yet because we're going to try interventions first, and then we're going to wait, till we're through with that process, and then we're going to do the evaluation. It doesn't kick out your 60-day deadline.
Katie, you had shared that consent needs to be in writing. What about those times where we can't get in touch with parents, or we can get in touch with them over the phone, but they're not returning anything in writing saying that they consent?
So you have to have it in writing to proceed with the evaluation, but I'm going to talk in a few minutes about what we do when we can't get consent. So hold that thought and I will get to that one. So in fact, that's my next slide. What if a parent won't consent? No. What if they say no? So if you've got a situation where the district suspects a disability, but the parent doesn't respond or doesn't consent, and it's two different situations, which is why I wanted to stop for a second, because I'm going to address those separately. You can weigh your options. If you don't have consent, the district can initiate due process. That you don't have to. You have not violated your child find obligation if you choose not to, but you can initiate due process. And there have been hearing officers and courts who have supported districts in a request to proceed with an evaluation over the parent's refusal to consent. So that can be done. But according to the federal regulations, if they don't provide consent or if they fail to respond, either one, you may, but you are not required to pursue the evaluation, through due process or if you deem that to be appropriate. So there are lots of cases on who determines the scope and process of the evaluation. Another thing that comes up is conditional consent. What if you get a referral, you try to get consent, and the parent says, well, I'll consent, but is conditional consent. And they say it's only going to be this instrument, or you can only use this person to administer the assessments, or I have to be in the room when the assessments are administered. There is guidance out there that says that conditional consent is no consent. So the district does not have to agree to whatever conditions the parent has placed on the consent to evaluation, because the district has broad discretion to conduct the evaluation without those conditions. And if the parent doesn't agree with the evaluation results, the parents have another remedy, right? They can get an IEE. So the conditional consent is considered to be no consent. As I said, you can also decline. Now, if a parent refuses to consent, then they're not going to get those disciplinary protections that I referred to earlier. So that's a little bit different. That closes the door on disciplinary protections. So if you get a referral and you don't evaluate, they get disciplinary protections. If you get a referral and then you try to get consent and the parent says no, that closes the door on the disciplinary protections. So keep that in mind also. Looks like I've got some more okay, so consent be provided. Okay, I'm sorry, let me back up. I've got a few questions in here. Does the timeline begin with a referral from the outside agency? So once you have a referral, you have 30 days to get consent. That's the timeline for the consent. And then once you have consent, you have 60 days for the evaluation. Can a doctor initiate a referral? If a doctor is speaking to you about a child, that's probably coming to you through the parent, right? Because the doctor isn't going to reach out and give you medical information about a child without consent to release that from the parent. But yes, a doctor can say that they think that the child is suspected of having a disability. The parent's going to provide you with that information, and that's really coming from the parent. Can consent be provided over the phone? No, you have to have a signature. It has to be written. Does the 60-day timeline begin at referral or consent? The 60-day timeline begins with consent. And then we use a response to intervention process to gather data and determine whether an ETR is needed. Does the school need written consent to begin RTI? RTI that is in the general education setting is not, you do not need consent for that. No. Okay. So if a parent does not respond to a request for evaluation, and I'm not seeing that in my notes, so I feel like I'm going to hit that later. If they don't respond to a request at all, this must be later in my notes, so I'm going to get to that one. So let's hold that thought. All right, so let's talk about evaluation paperwork. So conducting an evaluation, you have to use use an evaluation planning form. That's going to be your guide. That's the PRO 6. You also have to use the PRO 1, your prior written notice, as I mentioned. That's going to be, we are proposing to conduct this evaluation, and we've got consent, and so we're going to proceed with the evaluation. You're going to want your PRO 1. We cover PRO 1 drafting in one of the future ESELA sessions. That's in the procedural safeguards section. Parent consent for evaluation form, the PRO 5, the procedural safeguards notice, and the PRO 2, the parent invitation form to attend the ETR meeting. So those are some important documents that you're going to want to use through this process. So let's talk about who's on the evaluation team. So evaluation team is defined as well in the federal regulations as the parents and a group of qualified professionals. So the evaluation team is going to be just like the IEP team. It's going to include the parents, at least one regular education teacher of the child, unless the child is not participating in the regular education setting and they don't have one, one special education teacher of the child, and then a district representative. The district representative has to be someone who is qualified to provide or supervise the provision of specially designed instruction to meet the unique needs of the child with disabilities, is knowledgeable about the general education curriculum, and is knowledgeable about the availability of district resources. I recently had a parent complaint because the director of student services for that school district was not in attendance at their child's IEP meeting. The district rep does not have to be the student services director. It has to be someone who meets those 3 qualifications. So in the case of the complaint that we got, it was the principal. There was a principal there, and that principal, supervised the provision of SDI. The principal supervised the ISs in the building, right? Knowledgeable of the gen ed curriculum and knowledgeable of the available resources of the district. So it doesn't have to be a specific person. It just has to be someone in the district who meets all 3 of those qualifications. You also have to have someone who can interpret the instructional implications of the evaluation results. Now that may be, you can double dip there. That may be somebody else who's also already on the team, someone who meets one of the other qualifications. It may be the district rep. It may be the special education teacher. It just depends on who's on the team and what types of assessments we're going to be discussing. At the discretion of the parent or the district, other individuals who have knowledge or expertise regarding the child. So that can be a physician. You're going to have a medical release if we've got a physician in there. It could be someone from developmental disabilities. I attend meetings all the time where people bring in outside agencies or advocates. So anyone at the discretion of the parent or the district, and then whenever appropriate, the child with the disability. So for purposes of determining whether a child has a specific learning disability, though, you have to have the child's parents and a team of qualified professionals. That's a little bit different. You have to have the child's regular teacher or a regular classroom teacher who's qualified to teach that child's age or grade level. If they don't have a regular teacher, you do still have to have a regular education teacher. A child less than school age, then an individual qualified by ODE to teach a child of that child's age. And then at least one person qualified to conduct the individual diagnostic examination of children. So it could be a school psych, it could be an SLP, it could be a remedial reading teacher, but you do have to have those additional people on your team. That's the only change when you're evaluating for SLD. So initial evaluation planning.
We have a couple questions in the chat. I don't know if you want to read those first. Does a reevaluation require do school psychologists qualify as a district rep?
They might, if they meet the criteria. They have to be someone who is either able to provide SDI or supervise the provision of SDI. And then they also have to be knowledgeable of the gen ed curriculum and knowledgeable of the district resources. So it just depends on whether they meet the criteria.
If it is a reevaluation, does it require written consent if the parent isn't responding?
Not necessarily. And I am going to get to that, I promise.
In another training, we were told we had to have a gen ed teacher even if they did not attend gen ed classes. Can you confirm?
Well, I believe what the federal law says is that you have to have at least one regular education teacher of the child if the child is or may be participating in the regular education environment. I suppose if the child has potential to be participating in the general education environment, and that's part of the evaluation process, especially if you're in a, maybe continuing eligibility, reevaluation situation. I think it depends. If the child is not going to be in the regular education environment at all and doesn't have a regular education teacher, I don't believe that person needs to be a member of the team. But typically, if you're looking at it, it's still going to be helpful to have them there, especially when you're determining LRE, right? You want to have somebody who's knowledgeable about the general education curriculum and the general education setting when you're making that decision. So, but if the child is not going to be participating in the regular education environment at all, if they're in an entirely self-contained classroom with no regular education teacher and they don't have a regular education teacher, they do not need to be there.
Yeah, we
What
get that
if
question, Katie,
Oh.
we get that question a lot with DDs and like specialized schools that might not even have gen ed teachers.
Right. Right,
That's
'cause
mostly where those questions come from.
Yeah, I think, yeah, that makes sense. No, if they're in a situation where they are not going, I mean, and that's not your typical situation, but if they're in a situation where they are not going to be participating in the gen ed setting at all, then they don't have a gen ed teacher to be there.
What if a district rep is someone who works remotely and cannot really supervise the special ed staff providing the SDI? Could that person still be considered the district rep?
So let me go back. I always like to go back to the definition. So it says is qualified to provide or supervise the provision of the SDI. So it's someone who is qualified to be the supervisor. It doesn't necessarily mean that they are supervising that specific staff member.
If a school psych meets the criteria, can they act as district rep and lead the meeting as the school psychologist?
Yes, you can double dip. You can have one person who meets two different components of the IEP team.
And all of these team requirements, they hold for non-public schools as well, correct?
If you are, I'm not sure what you mean, but if you're dealing with a student who is placed in a non-public school, but you're conducting the evaluation as the district of residence, yes, those are the qualifications for the team.
All right, and I think that's it.
Okay. All right, great. Okay, so let's talk about the timeline. So as I mentioned, once you've got consent, you've got 60 days to conduct your evaluation. So you've got to know how to start that 60-day timeline. And this can be a little bit sticky. It seems like these things, when you read them on paper, they seem so easy. You get consent, you have 60 days. But what if the parent signs the consent form and they date it, and then 2 weeks later, you get it? So we've got a little bit of a lag here. Have we just eaten 2 weeks of the 60-day time period? You may have, it depends on your procedures and it depends on your documentation. So ODE says that the 60-day timeline, the consent form itself doesn't have a blank for the date consent is received by the school district, right? The parent dates it, but there's no blank on there for when it is received by the school district. And so the date is going to be assumed, unless you have other evidence, assumed to be the date the parent signed it. So if you believe you received it later, you've got to have documentation of that. So, a timestamp is, often things come into the district and we stamp them with a timestamp, and that's really critically important because that's going to trigger when the time period begins, is when it was actually received by the district. Now, it's not the receipt date for the special ed director. It's the receipt date for the district. Again, comes back to training. That's why it's so important for people in your buildings to understand that this triggers a legal obligation. So when that consent form comes in, it shouldn't be sitting in the teacher's desk, or in the kids' take-home folder or on a secretary's desk for 2 or 3 weeks while we're waiting to figure out what to do with it, because that time period begins as soon as it's received. So those are also calendar days and not school days. So winter break, spring break, summer break, doesn't matter. These are calendar days, 60 days. So make sure your processes are that when those consent forms come in, that they get time-stamped and they get to the right people immediately, because it's critically important that you get your process started, or you're gonna fall short on time. It is also clear under the operating standards that when the 60-day timeline falls on a holiday or a weekend or during a school closure, the ETR has to be completed the day before. So it doesn't matter if 60 days falls on a Sunday, the deadline's not Monday, it's Friday. So keep that in mind as well. So always avoid scheduling that meeting on the 60th day. You never know what can come up at the last minute, or if you're not going to get through all of the information in one meeting, scheduling it on the 60th day is cutting it too close. So I would avoid that as as much as you can.
Hey, Katie,
Yes.
just to follow up a little bit, I got a few texts and there's a few questions about what you said about somebody can act as a district rep and a school psych. Does that only apply in that situation, or there's a question, can a gen ed teacher also serve if they have both licenses as an intervention specialist and gen ed?
Yes, you have to have people who fill each purpose. You don't have to have a separate person.
Okay.
So if you've got a gen ed teacher who is the child's gen ed teacher and is also qualified to provide SDI, I'm hedging because I'm reading it based on the plain language of the statute, and I believe that to be the case. I think we should ask Laura. I'm going to ask Laura when she comes on just to check me. But I know that is certainly the case of the district rep, because that question comes up all the time. I think that as long as you have someone on the team who is capable of doing the independent roles, I don't know that it has to be separate bodies. But let me get back to you on the regular ed and special ed teacher, because I've never been asked that before.
Okay.
Typically we have both. Typically you have a meeting where you have a different person for each role. Oftentimes we do have somebody who is interpreting the results who's not a separate body. That sometimes happens. Sometimes the district rep, it takes on more than one role. But let me ask that question when Laura gets here.
Okay.
Yeah.
Is an intervention specialist required for a initial evaluation? Are they required to be on the team if they haven't worked with that child?
Yes, because remember the IS role. So the gen ed teacher role is a gen ed teacher of the child. The special ed teacher, it does say a special ed teacher of the child, or a special education provider of the child. But I think you've got to have a special education teacher there, regardless of whether the child is already on an IEP.
Can an ETR meeting occur during an IEP meeting?
Well, I mean, it's kind of the same group of people, but it's a different meeting. I mean, we're not going to, you can roll from one into the other. You can schedule the ETR meeting and schedule the IEP meeting back to back, but an ETR meeting and an IEP meeting aren't the same thing, because we can't develop an IEP until we know what the eligibility category is, whether or not they qualify and what the category is, right? And what their needs are. And then we develop the IEP. So from a practical standpoint, I guess you could kind of view it as one meeting if you're going to roll from one into the other, but they're two separate things. Right, you're determining two different things in those two meetings.
And there's a lot out there about, and I don't really, obviously not being a lawyer, I don't know what the misconception is based in, but about for initial ETRs, having the IEP meeting right after you're predetermining that yes, the student has qualified without actually holding the qualification meeting. So I think that's where that question probably comes from, if that helps add context.
Yeah, and I think that's fair. I think it can look like predetermination. It can also not look like predetermination. It can be done in a way that is communicated, that especially if the parent requests it. If the parent says, look, I'm going to take the day off for this, and I'm going to want to go from one into the next, you could convene the IEP team. And then if the ETR team decides that the child is not eligible, then you don't have the meeting. I mean, then you don't have a need for the meeting. But I mean, I've certainly seen it happen where they go from ETRs into IEP meetings. But yes, I agree. I think you need to be careful. I mean, I don't think you schedule the meeting in a way where you communicate to the parent, we're going to do the ETR and then we're going to develop the IEP, because we already know that this child is eligible. That, the purpose of the ETR is to make that determination. But if it's going to make it more accessible to the parent to do it in a row, there's no prohibition on having the two meetings in the same day.
One last question. Someone shared that they were advised by ODE that teachers who are dual licensed may fill both roles.
Right. So I would think so. I mean, and that I guess comment says it came from a preschool question, but you know, like I said, we'll have Laura fact check me on that one when she gets on, because she may have more experience, which I'm sure she does have more experience with that than I do. But the important thing is that you have people on the team who can provide that type of knowledge. And if one person has both types of knowledge, I think that can be filled by one person. Okay, so we've talked a little bit about the timeline and avoiding the meeting on the 60th day. So that's pretty important. Again, okay, this is where we're talking about the interventions again. So same as the question that came up earlier, the district cannot use interventions to delay unnecessarily a child's reevaluation to determine eligibility. So if the interventions haven't been implemented prior to referral, you still should implement appropriate interventions during that 60-day period, but it doesn't kick out your timeline. It doesn't change your timeline. So now that timeline does not apply in certain situations. One is if the parent repeatedly fails to produce the child for evaluation. So you get a referral, you get consent, you do the ETR, planning meeting, you get consent, and then the parent doesn't bring the child in for the evaluation. If they continue to do that, you need to document it, of course, but that will change your timelines, because you can't do it if the child isn't there. If the child enrolls in a different school after the time frame begins, so let's say you're at your point where you've triggered the 60-day timeline and then the child enrolls in a different school, as long as the other school, the new school, is making progress to ensure prompt completion of the evaluation, and the parent and the new school have agreed to a timeline, then your obligations to complete the evaluation within the 60 days don't apply. So obviously you have to cooperate with the transferring school on the assessments that have been done on, the data that you have, and you coordinate with that. But if the student transfers to a new school and the parent and the new school are working to get that evaluation done promptly and they've agreed, then you do not have the obligation to finish it in the 60 days. Now, don't forget, though, that if the child is being determined, is being evaluated for SLD, the parents and the district can agree in writing to extend the time frame. All right, let me move to this one. Okay, so initial evaluation. Let's talk about initial evaluations next. So you have to have procedures to determine whether the child is a child with a disability, and to determine whether the educational needs, what the educational needs of the child are. You have to use, there's a whole list in the operating standards of what you need to do to evaluate that child for these purposes. You have to use a variety of assessment tools and strategies. You can't rely on just one thing. You include information provided by the parent. That's something that you need to consider as well. Information that may assist in determining whether the child has a disability and what needs to go into the IEP. That's really the goal of the ETR. One, do they qualify, and what are their needs, so that we can use that to develop an appropriate ETR or an appropriate IEP for the child. You should not use just a single source of information, not a single measure, not a single score as the sole criterion. And you should use technically sound instruments that may assess the relative contribution of cognitive and behavioral facts, physical and developmental factors. You're required to use assessments that are selected and administered so that they are not discriminatory on a racial or cultural basis. You use assessments that are provided in the child's native language or in the mode of communication in the form most likely to yield accurate information on what the child knows and what they can do academically, developmentally, and functionally. You should only use assessments for the purpose for which that assessment is designed, for which the assessments and measures are valid and reliable. And you should have them administered. They have to be administered by someone who is trained and knowledgeable, about those assessments. They also have to be administered in accordance with the instructions of the provided by the producer of the assessment. So you have to use it in the way it's intended, for the purpose in which it's intended, by somebody who is knowledgeable about it and knows what they're doing, right? I mean, some of this is common sense. use assessment tools and strategies that provide relevant information that directly assist persons in determining the educational needs of the child. And then if the child has impaired sensory manual or speaking skills, assessments that reflect their aptitude or achievement that the test is supposed to measure, rather than reflecting that impairment of the sensory manual or speaking skills, unless that's what you're assessing. But just, you need to use assessments that are going to accurately reflect what it is that the assessment is trying to measure. And then you also, of course, have to assess in all areas of suspected disability. An evaluation has to be sufficiently comprehensive. So you're not going to just assess in one area. You need to do all areas of suspected disability. And a medical consultation is encouraged, especially for a preschool or school age child, but on a continuing basis, especially if there is a change in the child's behavior or a change in educational functioning, new symptoms have developed. If you can get consent to be in consultation with the student's medical provider, the more information you have about a child, the better able you will be to meet that child's needs. So medical consultation is great. If a parent says, I want to bring my doctor, absolutely. If the parent doesn't ask and you think you need to consult with the doctor, you should try to get consent and ask if that medical professional can be involved.
Katie, we have a question. I don't know if you want to answer this now or hold off, but if a preschool age child, if a referral is made by the parents, but the district is requiring the family to register the child before moving forward with the consent, and the family takes longer than 30 days to register, does that negate the referral to consent?
For a preschool age child, a district is requiring registration before moving forward. Well, you all are playing Stump the Presenter today. I don't think that negates the referral. I think even if the child isn't registered, if they're a child in your district and you have a child find and they want an evaluation, you do an evaluation. I mean, preschool's not mandatory. We don't have to send the kid to preschool, but we do have to evaluate the child if we suspect a disability. So I think you still have a child find. Wow, you guys are throwing all kinds of questions at me I've never gotten before. Okay, so preschool evaluations. Where appropriate, they should include a physical exam by a doctor in cases where the disability is primarily the result of a congenital or acquired physical disability. Again, some of this is common sense. It should include a vision exam by an eye specialist if the disability is the result of a visual impairment. And it should include an audiological exam completed by an audiologist where the disability is primarily the result of a hearing impairment. So keep that in mind when you're dealing with preschool evals. So evaluation planning, part of the initial evaluation, reevaluation, you have to have a review of any existing evaluation data of the child. So you're going to review the existing data that you already have as part of an initial evaluation. If you happen to have the data, certainly a reevaluation. And with or without a meeting, look at that data. Evaluations and information provided by the parents, I mentioned that before, but the parent information and any evaluations that the parents have conducted or had obtained on their own, that has to be considered. Current classroom-based local state assessments, observations by teachers, observations by related service providers, data on the child's progress in the general curriculum. For preschool age students, data about the child's growth and development. Those are things that need to be considered by the team. Data from previous interventions, including if you're doing those interventions during that 60-day evaluation period, that data should be considered by the team. And on the basis of that review and input, then you identify what additional data you need in order to determine whether the child has a disability, what the child's educational needs are, their present levels of academic achievement, related developmental needs, and whether the child needs special education and services. So it's pretty broad. I mean, when you're looking at what you need to conduct an evaluation, you need all the information that you can possibly gather relevant to that child's disability and related needs. When you're doing a reevaluation, so a reevaluation every 3 years, unless the parent and the district agree that it's unnecessary. The reevaluation team is the IEP team and any other qualified professionals who are needed to assess the information. Reevaluation also have to be conducted anytime the district determines that the educational or related service needs warrant a reevaluation. So as needs warrant. I recently had a parent who requested an accommodation of a district that was something that they had never really evaluated for. It was something that their child's existing ETR didn't support. But there were some changes going on with the child in their academic performance that may have warranted a need for this new accommodation. Their 3-year ETR wasn't due for another, 9 to 12 months. I mean, it was pretty far out. So the district, of course, just said, hey, how about we just go ahead and do our reevaluation now? And they got consent and they did the reevaluation, and they were able to gather the data they needed to see if the child needed this additional accommodation. So just keep that in mind, that it can be done sooner. And the district has an affirmative obligation to propose a reevaluation anytime it's warranted, and specifically included in this mandate is to conduct a reevaluation when the student's improved academic and functional performance warrants reexamining their eligibility. That's something I think that you don't think about, but the goal of special education is to provide students with services and supports to enable the student to make progress without the need for specialized instruction. And so there are certainly cases where students are no longer eligible. They no longer need the specialized instruction. And that's a time when a reevaluation would be warranted. So if a student has improved academic achievement and functional performance and is no longer going to need special education, they should be reevaluated to determine whether they still meet the eligibility standards, which is what Laura's going to talk about shortly when she comes on. So anytime the conditions warrant, you're going to do a reevaluation. You also need to do a reevaluation if the child's parent or teacher requests a reevaluation, no more than once a year. But if a parent says, I want a reevaluation, we go ahead and get consent and do a reevaluation. If the child is transitioning from preschool to school age services and they're identified as developmentally delayed, you need to do a reevaluation to see if they qualify for school age services. Anytime you suspect a change in disability category, you have to do an evaluation to make a change in disability category. And anytime before change of eligibility, except when the student is either graduating or aging out. So reevaluations, like I said, can't be more than once a year, except unless the parent and district both agree otherwise, but a parent can't demand a reevaluation more often than annually. And reevaluations are subject to those same general evaluation procedures as an initial evaluation. So we get the question often on consent for a reevaluation: is consent required? If new assessments are being conducted, the answer is yes. You cannot conduct a new assessment without consent, unless the district can demonstrate that it made reasonable efforts to obtain consent and the parent failed to respond. Now, that is different from a refusal. But if it's time for the reevaluation and you need to conduct assessments to gather the data you need for reevaluation, and the parent is AWOL and they are not responding, you can conduct the reasonable. If you've made reasonable efforts to obtain consent and they don't respond, you can move forward. If there's not going to be any new assessment and you're just doing a review of available data, then you don't need consent. If the parent refuses to consent, now again, different from failure to respond, but if they affirmatively say, no, I do not consent to the evaluation, you've got 4 options. You can agree that a reevaluation is not necessary. You can conduct the reevaluation without new assessments, so you can do a data review and go forward with your ETR. You can request a due process hearing and pursue an evaluation, or you can decide not to pursue an evaluation. So those are your choices. If you are going to do a reevaluation, you do need to consider the existing data that you already have, determine what additional data you need, try to get consent for that. If you can't get consent for that and you want to just do the ETR based on the data, you can do that if you can't get consent. So an example of additional data would be if the student is identified under one category, but as time progresses, they demonstrate needs that were never evaluated. So the situation I just talked about where the parent said, hey, I think there's an additional need for this accommodation. The ETR we had, it didn't address that need. So we had to reassess for that purpose. So a student with a learning disability in reading, let's say this student becomes so concerned about their inability to keep up with their peers that they develop emotional or behavioral issues that have never been assessed because the child didn't have emotional or behavioral issues in the past that were manifesting in the educational setting. The law requires a district to address any need the child has, but is helpful to consider whether an evaluation like an FBA is necessary to gather data to determine the IEP needs of the student. You have to assess whether a child continues to have a disability and the educational needs of the child. We kind of talked about that, the present levels of academic achievement and related developmental needs, and whether they continue to need special education and related services, and whether any additions or modifications to what's already in the IEP might be needed to enable the child to achieve the measurable goals in their IEP and to participate as appropriate in the gen ed curriculum. So here again is a reference to remind everyone that the team must continually review a child's eligibility. It's not the case that once someone is identified under the IDEA that they remain so for life. Under 504, eligibility protections are continuing based on whether someone has a record of impairment. That is not true for the IDEA. So there may be 504 protections, but that's not necessarily the case under the IDEA. So it's also important to mention that if the team does not determine that the child continues to have a disability under the IDEA, that doesn't mean we automatically go into a 504. 504 eligibility and whether or not a child needs a 504 plan is a separate assessment. We do a separate evaluation and reach a determination on eligibility under 504.
Katie, we have a couple questions. I think you may have answered a few of them, but I just want you to double check. If you go up under where I added a link for open office hours for early childhood, the first question is Amanda Holcomb's.
Okay, let's see if I can find it. Okay. If you want to add a math goal, but it is not an identified area of need on the ETR, can you add it to the IEP or do you need to reevaluate? So you've got to have data to support that math goal. So I think this is pretty specific and depends on the situation, but if you're identifying a need, you've got data that supports the identification of that need. Do you need to, do you need to conduct an evaluation? Not necessarily, because it sounds like you've got records and that gives you the information that you need. I don't think you necessarily have to do an evaluation if you have the data that you need. But if you want to add the math goal based on that data, you've got to base it on the data that you have. Okay, a student who qualified under speech, but the teachers have now identified academic needs. Can we add academic or behavioral goals to the IEP if the ETR only identifies speech needs? I think I think you've got to have the data. I think you need to assess that. You've got to look at the need. You've got to look at the disability, and then you have to figure out what the educational needs are based on that disability. So, I think you have to evaluate that. I mean, what goes in the IEP has to be supported by the data that we have. Okay, so if an ETR was less than a year ago and the parent asks to determine if a child is dyslexic and the team agrees to more assessment, do you need new consent? Yes, because the consent form, remember, has to be pretty detailed. It has to include what assessments are going to be used, what we're assessing for, what records are going to be released and to whom. So if you're going to do an additional assessment, then you need consent for that additional assessment. Okay, not related to reevals, could another initial evaluation be completed following did not qualify if new data supports a need for an SDI, but it hasn't been a year from the previous initial evaluation? Yeah, the limitation on once a year is unless the parent and the district agree. So if the parent and the district both agree that, that a reevaluation needs to occur more frequently, then that can happen. The purpose of the 1 year is that we're not going to demand a reevaluation, every day, every month, every week. It's going to be a year apart. Okay, if a district makes reasonable attempts to obtain parent consent to complete a reeval, but does not obtain consent, the district can obtain new data. So it depends on the reason they haven't obtained consent. So if the parent refuses to consent, then you cannot do a new evaluation. If the parent simply doesn't respond and you can demonstrate that you made a reasonable effort to obtain that consent, then you can move forward with the assessment. But it has to be a situation where you demonstrate that you've made reasonable attempts to contact the parent and the parent has not responded. Different from a refusal. So when you say, makes reasonable attempts to obtain consent and doesn't obtain it, just make sure it's not because the parent said no. Is there a specific form somewhere to waive a reeval? If the parent and the district have both agreed that we're not going to do a reeval, you would document that in a PRO1. The needs need to be identified in the ETR. Yes, the needs need to be identified in ETR. Yes, that doesn't necessarily mean you need to do new assessments every time, because you may have data and you may not need to do the assessments. You may have data that supports the additional needs that are being added. Teachers collect a lot of data, so there may be data that supports the addition of a, the chat is moving as I'm trying to read it as new questions come in. There may be data that supports the addition of a new goal area. Classroom data can be as reliable as a formal standardized assessment. In the past, we were told that if there is sufficient data to substantiate a new goal area, it would be okay. Yeah, so again, I mean, the needs have to be identified. I'm not quite sure what the question is. I think we're getting off into a different area. I think you all are asking me whether or not we have to reconvene the ETR team every time we want to add a new goal to the IEP. Is that what?
That's what I'm understanding.
That's what I'm understanding the question. Okay. All right. Let me come back to that in a minute. Let me just skim through the rest of the questions because they're popping up so fast. Hang on one second. So you need the data. Okay. Reeval. Okay, let me address the PRO1 question. If you make reasonable attempts to consent for reeval and parents don't respond, do you need to write a PRO1? Absolutely, you do. Anytime you make a decision, you need to inform the parents of that decision. So yes, if you are going to proceed with the reevaluation when the parent has not responded at all and you've documented those reasonable attempts to obtain consent, you should put it in a PRO1. And that PRO1 is the place where you can put your self-serving statements in there that document all of the attempts that you made to reach the parent and the fact that the parent has not responded. That's the best place to document that. So absolutely, you need to do that. Okay. All right. So I am going to let Laura address your question also about the ETR. She's going to be on in just a few minutes, and I'm gonna toss that one to her. Okay. Am I caught up on questions except for that? I think.
Yes, you're good.
Okay. All right. Sounds good. All right. So no assessment needed. We just talked about that. If the evaluation team determines that there's no need for additional data to determine the child's needs or whether the child is continuing ineligibility, then you notify the child's parents of that determination and the reasons. So of course, like we just said, you're going to put that in a PRO1 as well. All right, so it is 10:15. We are going to take like a 10-minute break. So I've got 10:15. Why don't we come back at 10:25? And Laura's going to be here. We're going to talk about those two questions that we asked about the gen ed teacher, special ed teacher, kind of double dipping, and about the need for an ETR to add a goal when we've got data to support the need. And we will be back in 10 minutes.
So, are there any outstanding questions, Katie, before or?
Yes.
Okay.
We do. We have a couple of questions. So first, I was asked what we talked about how people on the IEP team, you can have a district rep who also serves one of the other roles. But this very active audience and curious audience asked me if there can be a gen ed teacher who is licensed as an IS who fills the role of both the gen ed teacher and the IS. And I said, I don't know the answer to that because I've never been asked that before. So I thought we would ask you with all your wisdom.
Well, the rules talk about a general education teacher of the child and a special education teacher, a provider of the child. So the question would be, whether that person would serve in those dual roles with that qualifier. So you can't just pull any old general education teacher. So for example, you've got a student who's transitioning from preschool to school age, and oh, by the way, this special ed person is also certified to teach PE at, high school. So wouldn't that person would never be a general ed teacher of that particular child. And the reason for the general education teacher is to, the role of the general education teacher is really prescribed in terms of what they're supposed to talk about. And it's really supposed to be discussing what are the expectations for general ed for that particular student at that particular level. So I think the answer is the typical lawyer answer, which is it depends, but it also depends on the nature of where that student is and what that person who's holding those two roles, what they could contribute in terms of the conversation on eligibility.
Okay, thank you. Okay, so the other question that we got, and we had a lot of questions on this, so there may be some variations of the question, but I think what the basic gist of what we're trying to figure out is when you have a student who is not due for reevaluation, say we're halfway in between, it's 18 months in, and we're at an IEP annual review, and they want to add a math goal when the student previously only had an ELA goal or a behavior goal. And the data that they have based on the student's performance and observations from the teachers, it doesn't require evaluation, but we all agree that this math goal is needed. They wanted to know if we need to go back to the ETR phase and do kind of a data review to identify the needs before we add this to the IEP.
I don't think so. I mean, if the math goal is related to, let's just think about, let's say the student is identified as other health impaired and they have executive functioning issues. And so where that's manifesting is within their, English language arts, but now it's bleeding over into math. I think you can tie that to the needs that are identified in the ETR. If it is something that is a new related service, you will need to have an evaluation to determine the need for those related services. So that is the piece that I would say would kind of be outside that, but you can do that with getting consent and moving that process forward. But for academic goals, probably not.
Okay, I think we're caught up on questions, and so I will turn it over to you to talk about eligibility.
Okay.
All right.
So I think as Katie teased up, we're going to be looking at, what are the fundamentals of making eligibility decisions? And, really it's critical that you get those fundamentals, you have a comfort level with those fundamentals, because that really forms the basis for the entire IEP process. And I have, and as we move on to the next slide, which is my very, very artistic rendering of a three-legged stool. Like nobody is going to call me to be their artist, but this is what we have. And we put the three-legged stool out here as a reminder that you need to have a good foundation, a solid foundation for making eligibility determinations, because many districts feel caught in the middle between multiple groups. You have families who may rightly or wrongly believe that they need special education and they need to be identified as an individual with a disability in order to receive appropriate services. So, they're chasing that because they think they're not going to get it any other way. And then you have educators, maybe regular education people, who resist changes to the method of delivery of services. And they might believe that the student needs to be in special education to get something different. So not my job, you need to be in special ed. And then administrators might believe that it's just easier to identify a student than being in conflict with a parent. And then you have state or federal agencies that say, listen, school districts, you are over-identifying students. So here we've got all of these competing conversations and competing positions. And in order to effectively navigate all of that, districts really must understand the fundamentals of the eligibility process. So we're going to get into some cases, but you should know that courts typically focus on these three central factors in most eligibility determinations, and they evaluate how those factors intersect with each other. So you've got this stool, and the reason we create this visual here for you is to emphasize that you have to have proper balance. Like, all three legs are important. If one leg is emphasized at the expense of another, the stool is going to be unbalanced and it's not going to provide a solid foundation for your decision. The three-legged stool also provides a good example of the need to focus equally on all three elements when you're doing eligibility determinations. If you don't evaluate and look at and consider and discuss each element and render a decision on each, you can't determine eligibility. Now, it might seem that these factors are straightforward. You've got a disabling condition, you've got adverse effect on educational performance, you've got need for special education, but I can tell you that educators and teams and hearing officers and courts have been somewhat varied in how they apply these terms and what they determine constitutes, what is a disabling condition, what it doesn't mean to be adverse, what is educational performance, and what establishes a need. So when we think about these things, we're going to go through each of these so that you have a good framework for each. So first is disabling condition. And that is our next slide. So the child with a disability, is going to meet, be in one of the categories. So the first step is that you have to recognize that your eligibility determination has to be based on the standards set forth in the IDEA. And so the first step in making those eligibility determinations is to make sure that your team is reviewing the definitions of each disabling condition each time. So you might have a student, let's just take autism as an example. You may have a student who has a diagnosis of autism. They've received that from their healthcare provider, but the diagnostic criteria is different than the definition of a student with a disability under the category of autism. So diagnosis doesn't mean disability. So for those of you, like I have, let's see, where is it? For those of you who keep your handy dandy copy of the DSM, like I have mine here, know what the definitions are for mental health disorders. Know that there may be a difference in how a student was, diagnosed with something versus what the IDEA tells us is their disabling condition for educational purposes. Those two things are very different. So let's go back to autism. So autism, the disability category requires the child to have a developmental disability that significantly affects verbal and nonverbal communication and social communication that adversely affects the child's educational performance. You're not going to see that in diagnostic criteria, but that is the educational definition of a student with a disability under the category of autism. And that definition also contains some rule outs. So for example, autism does not apply if the child's educational performance is adversely affected primarily because the child has an emotional disturbance. So then now you got to look at this rule out and you have to look at the definition of emotional disturbance to actually consider whether the student meets the eligibility criteria. And for those of you who don't have it committed to memory, I'm sorry, was I hearing a question? Maybe not. Okay, if there is, let's pop it in the chat so then I can see it. I do see that I have a question, and I will get back to it. So if we're on emotion, we started with autism, and now there's a rule out for emotional disturbance. So now we have to go through the definition of an emotional disturbance, which, a child has one or more of the following characteristics over a long period of time and to a marked degree that adversely affects the child's educational performance. So that's inability to learn that can't be explained by certain factors, inability to build or maintain satisfactory interpersonal relationships with peers and teachers, inappropriate types of behavior or feelings under normal circumstances, and on and on and on. So you can see that when you get to these definitions under IDEA, you really have to have a good understanding of what each element is of those definitions when you're trying to determine, is the child meet the criteria as a child with a disability. So I always recommend to those who are making eligibility determinations to have those definitions on hand. Those are contained in your operating standards under 3301, 5101. And, you know, you will have all of the definitions right there, and you should make it a part of the conversation to once you're making that eligibility determination, so that you can say, does this child have a disabling condition? Okay, and that's critically important so that you can manage expectations in the sense that you're setting the foundation that our decisions, our definition are based on educational criteria and not based on what the doctor writes on a prescription pad, okay? Because what the doctor writes on a prescription pad is not going to automatically lead to IDEA eligibility, just like it won't automatically lead to services or placement or other things. So starting that, setting that as an expectation at the very beginning of the process will help you down the road. Now, know that not all children with diagnoses are IDEA eligible. It's only those children who are currently, and I'm going to use the word handicapped, I know it's not right, but currently educationally handicapped. That is how the definition is. So those are the individuals who are protected by the IDEA. So it's an educational disability, not necessarily a medical diagnosis. And that the definition of disabling conditions is exhaustive, meaning that's all there are. There are 13 categories. Now, sometimes we get the question, well, do you need to have a medical diagnosis to establish eligibility and establish a disabling condition? And the answer is no. But if your team thinks that you do need one, that it is necessary for the team's determination, then the district must provide that evaluation, the medical evaluation, at no expense, okay, at the district expense. So there is this concept of a definition, the difference between big D diagnosis or big D disability, whichever you want to call, capital D, I have a diagnosis, but you're not going to get to the little d disability unless you meet the definition. So another D, the definitions. Lots of students, sorry, there's my phone going off. Lots of students have diagnoses and they don't meet the educational criteria as a child with a disability, because maybe that diagnosis doesn't create an adverse effect on educational performance. Maybe they have a diagnosis and they don't require, they don't have a need for specialized instruction. So again, those are your three legs of your three-legged stools. And in some of the cases that we've provided for you, we highlight that kind of the difference between diagnosis and disability. One of the cases I want to talk about is a San Francisco case. It's a 2015 case. A student did have multiple diagnoses, ADHD, post-traumatic stress disorder, and fetal alcohol syndrome. But then the student did meet all of the expectations or exceeded all of the expectations by the end of the school year. They received average to above average grades. And the determination was that the district's decision that the student didn't meet the eligibility was accurate. And in that case, which is why I'm highlighting it, the administrative judge said the mere evidence that the student suffered from a medical or a DSM diagnosis did not mean that the student met the criteria for special education under the IDEA. So this book doesn't control it, okay? It is what we find from an educational reason. That's what's controlling. And similarly, if a student has a disability, has a diagnosis that could someday create an impact on their education, that also doesn't establish eligibility. So a child who's at risk of having some sort of problem or concern, a difficulty in education, that's not enough to meet the eligibility. So the statute, the IDEA, is remedial, meaning it is there to address adverse effect, not prevent it. That's just the way that it's written. There are some cases also in your materials that highlight this point. There was one where a child had a progressive genetic disorder where, you know, at some future date would likely qualify, but at the point at which the eligibility determination was made, they didn't. Okay, I'm just going to take a look at my question here to see if it relates to what I'm talking about. Okay. All right. So first question is, so if you're, it sounds like if you're just adding academic goals in a reevaluation doesn't not need to be completed, but if it's going to change disability category or add a related service, a reevaluation, I would do a reevaluation if you're going to change eligibility category for sure. And if you're going to add a related service, yes. But then, and then what about behavior and executive functioning? And I think that just came in. So what about behavior and executive functioning? Well, if a student, let's say a student is identified as a child with an emotional disturbance. I actually had litigated a case like this. They had some mental health diagnoses. The student was having all kinds of difficulty in the home environment, in the community, but at school, they held it together. They were able to meet, you know, their academic requirements. They had appropriate interactions with peers. They were attending school, but they had a mental health diagnosis. They were having significant issues at home with their parents, but it didn't manifest into a disabling condition that had an adverse effect on their education. So I would be looking at behavior and executive functioning as, what is our data that this, whatever diagnosis, whatever executive functioning disorder is actually having an adverse effect on the student's education? Not that it could. Maybe the student is, diagnosed with ADHD because of their executive functioning skills, and they're taking medication and it's doing the trick, and the student is doing well in school. So you need to have all three legs of the three-legged stool. And if you don't, the student is not eligible. So in your materials, there's a case called Marshall Joint School District. It was an interesting case because it does address this idea about having a potential adverse effect. And it also has some really good language in it that talks about the interplay between the medical diagnosis and eligibility. And so I have a quote up on my screen I can read to you, which says, "This brings us to a key point in this case. A physician's diagnosis and input on the child's medical condition is important and bears on the team's informed decision. But a physician can't simply prescribe special education." Okay, I'm just going to pause there. A physician can't simply prescribe special education. Rather, the IDEA dictates a full review by a team and a representative of the local education agency. Okay, in this case, no one suggests that the student wouldn't benefit from or need continued related services. The record is clear that he would benefit from the services, but his need for such therapy is not what the school is charged with considering when it evaluates the need for special education. Those are both related services used to give the student a full benefit of education. And so in that case, the court discounted the testimony of the child's physician and found that the physician was not a trained educational professional and had no knowledge of the subtle distinction that affects classifications under the IDEA. The doctor wasn't familiar with the curriculum or what was expected of the student, and the court summarized the doctor's testimony as conclusory and held it didn't provide a reasoned basis for finding that the student needed special education. So again, there's a distinction between diagnosis and disability. Are there any recent cases on socially maladjusted scenarios disqualifying students for ED classification? No. Social maladjustment is one of those things that it sounds nice in the law, that, okay, we've got social maladjustment. And the problem is, what does that mean? Okay, social maladjustment, some have opined that social maladjustment is aligned to what is under the DSM of conduct disorder. Maybe. It becomes a very difficult thing to prove for school districts to have that as a rule out. to be honest with you. So no, I haven't done an exhaustive search, but I would say that typically I don't find that when there is a interest in having a rule out of social maladjustment, that it is easy to prove that. Just my 2 cents. All right, so we talked about disabling condition. The next leg of the three-legged stool is looking at, is there an adverse effect on the student's educational performance? Okay, the IDEA does not define these terms. What is an adverse effect? What is educational performance? But we know from the case law that educational performance does not exclusively mean academics, right? There's so much more that we are preparing these students for further education, employment, and independent living, right? So the areas that we are trying to address in terms of student need is beyond just what are their test scores. It's beyond their standardized assessments, and extends into other areas like behavior, like emotional development, like interpersonal skills. So if you have a student who can't form social relationships, they can't attend school regularly, they can't control their behavior, but they do well academically, you still might have a disability that is adversely affecting the child's educational performance. Just last week, I got a call and it was an eligibility issue, and the student was struggling to attend school, had some hospitalizations, but when they came to school, and that's what the call was about, when they come to school, they do great. And my response was, coming to school is part of the process. And if they're not able to come to school because of a disabling condition, you may have fallen down on your child fine obligation, and you may not have appropriately considered the impact of other factors when determining, the student's need. All right, now I'm going to look at my question. When a student's mental health is impacting their educational performance and requires special education, who is responsible for those IEP goals? Well, the school district is responsible for delivering services to address whatever need is adversely affect the child's educational performance. So the IEP team determines who's appropriate. Can those support services be done by an intervention specialist? Can they teach them de-escalation techniques? Can they teach them, can they do social emotional programming? Maybe. Does that require the services of a mental health professional? Maybe. But the district and the IEP team determine who is responsible. There's not a one size fits all response to that. Okay. So when you think about educational performance, your those academic areas, including your grades and your test scores, those things are easy for us to wrap our head around. But there are other things. So if you have to ask questions that go a little deeper into those non-academic areas. And so in your materials, there are quite a few cases that talk about how those non-academic areas come into play. So looking at social skills, looking at behavior in the school environment. Sometimes when students are struggling with certain issues, let's say, somebody in the family was, passed away. Let's say the student house was destroyed in a hurricane. Let's say that they're being shuffled from foster placement to foster placement. Let's say that they're a victim of abuse. What areas are affected might turn, and whether areas of effect are affected educationally might depend on how well the child compartmentalizes all that is happening outside of school. So somebody who had any of those scenarios, any type of trauma, maybe they're really good at compartmentalizing, and they come to school and they interact appropriately with peers and they meet expectations. But other kids, they fall apart. So when you're looking at somebody who's had trauma or has mental health, sometimes you're really looking at what is happening outside of school can impact on those academic areas. Maybe they're not getting good grades, and those other things, their demeanor, their interaction with peers, their ability to maintain satisfactory relationships with teachers. All of those things are important to look at. And there are some cases in your materials where there's some kids who look like they're doing a better job than others, and they're found not to be eligible for special education service because there isn't an adverse effect on their education. So another thing that clues us in that we have to look beyond academic areas is the actual IDEA purpose statement, which is on our next slide. We have it reprinted here for you just so you can see that when we're looking at what is FAPE, this is the definition of what is the IDEA, right? The IDEA purpose is to ensure that all children with disabilities have a free and appropriate public education that emphasizes special education and related services designed to meet their unique needs and prepare them for further education, employment, and independent living. That's not all about academics, okay? So we're looking at functional goals. We're looking at, and you know, when we're thinking about IEPs, we're looking beyond just grades. What are the functional goals designed to meet the child's needs, excuse me, and make progress in the general curriculum, and then meet any other educational needs that they might have that result in their definition, in their result from their disability. So what is functional? Like, what does that mean? Well, when the IDEA was reauthorized, there was a request for the Department of Education to define that term. And the Department of Education said, no, we don't think it's necessary to include a definition of function in these regulations. We believe that term is generally understood to refer to skills or activities that are not considered academic. So functional is not academic. It's related to a child's academic, not related to a child's academic achievement. So it's used in the context of routine activities of everyday living. All right, so that's where we go with academics or educational performance. So what does it mean to have an adverse effect? Okay, is it just some little itty bitty negative effect, or does it have to be significance? And some courts and hearing officers are varied in their perspective on what does adverse mean. Does it mean that the effect prevents you from meeting your potential? Meaning I have a very high IQ and I'm not meeting my potential, so therefore I'm operating on an average basis, so therefore there is an adverse effect even though I am above average. So there are some courts and there's some hearing officers that find that a child with satisfactory performance may still have a disability that adversely affects educational performance because it inhibits their performance. It creates some difficulty with their performance, or merely because the child's performance could be improved. But there are others that require the disability might significantly affect performance in order to qualify. So this is where it kind of explodes the brains of us lawyers, because we're trying to identify what is the bright line rule, and guess what? Spoiler alert, there isn't one. Okay, so sometimes we look back to other sources to try to figure out what does this adverse mean. There is some legislative history. So when you go back into the history books, when the IDEA was originally enacted, Congress was pretty clear about its concern about over-identifying students as students with disabilities. There's language in the House report that suggests that Congress did not intend to identify what they called slow learners as disabled. And when they were discussing who might have something like a learning disability, the House report said that the law was designed to reach those who are significantly handicapped. When the law was reauthorized in 1997, Congress did restate its concern about over-identification, and that theme is something that we continue to hear about. But in any event, the cases are all over the place, and that's why we put them into your material so you can understand that there is a split of opinion on this issue. I think there's a better argument that the adverse effect has to be more than minimal. It has to be more than something that just impedes performance. But again, when you go to litigation on these things, it really depends. Courts are all over the place. So, and some courts nowadays have been looking at things and saying, well, what is the difference between the student's performance and their ability? And that sometimes is compelling for parents, school teams, courts, and hearing officers. But again, your materials highlight some of the things that courts have been thinking about. All right, the Mr. and Mrs. I case is one of those that I wanted to highlight. So this highlights the the belief by some courts and hearing officers that the plain meaning of adverse means that adverse effect is any negative effect. And they argue that the lack of a qualifier, like significantly, there's no significantly adverse effect, there's no substantially, doesn't say substantial adverse effect, means that any negative impact on educational performance, no matter how slight, will meet the criteria for eligibility. So in that case, there was a student who had at that time a diagnosis of Asperger syndrome, and the student had difficulties with peer relationships. The student had superior academic performance, but some difficulty with peer relationships. They experienced occasional sadness during 4th and 5th grades, but nevertheless, they always followed school rules. They always turned in their work. The student had friends, but the student wasn't in the popular crowd, and she didn't like going to school. I mean, I have a middle schooler. That kind of sounds very typical, right? So her communication skills were tested as above average, but she was described as by one evaluator as having poor pragmatic and social language skills. So in the beginning of 6th grade, she was intent on making more friends and being in the in crowd. So she started dressing in a different way. She began to slack off in her work. And, people noticed, and her teacher and her mom came up with a contract to get her to return to her former, strong academic performance. But she had her ways, and she got into a fight with her mom about homework. And when her mom left the house, she took pills in a suicide attempt. So she went to the hospital. She was directed to stay out of school for 2 days, but the parents promised her that, you're never going to have to go back to that school since you were having so much difficulty there. So at that point, the family referred her to special ed, for eligibility determination. They homeschooled her for a period of time. And during that process, she was enrolled in a private school. And while she was at this private school, she succeeded. She had positive relationships with peers. She thrived academically. They didn't have any supports in place for her. And the teachers there described her as a normal, active participant in the school, didn't need anything. But so in the meantime, the school district is doing their eligibility determination, and they find she's not eligible. They considered OHI, they considered ED, they considered autism. And they said her condition did not adversely affect her educational performance, okay? The team did find that she was eligible under Section 504 and offered her speech therapy to address pragmatic language skills and tutoring if necessary to return to school. So family said, I don't agree with that. They went and filed for due process, and the school district prevails at the hearing and at the next level appeal. Then the parents take it further. They appeal to court, and then they win at the next 2 levels of appeal. Okay, so this is how it's the ping pong match going back and forth. So when it gets to court, the court did say that any negative impact on educational performance is going to meet the criteria. They rejected the school district's argument that the term requires some significant or substantial limitation. And when they looked at educational performance, they interpreted that very broadly. They relied on a standard in that state, which was Maine, which is similar to our standard in Ohio, which defines educational performance as including academic and non-academic areas. So, just like we have, we're supposed to target all of the areas of the child's disability, whether academic, physical, emotional, or social. So when applying those standards, the court had no problem finding that the disability adversely affected the child's educational performance. And they said, despite her excellent academic record, she had some negative impact on an area of social communication. She was isolated, she was inflexible. So, know that you're looking beyond academics. And this is also just a little tidbit that things get out of your control when it goes to court, to be honest with you. All right. Moving on. Let's look at, we get to what is your need for special education? Okay, so you still need this is your 3rd leg of the 3-legged stool. And what does it mean? There's all kinds of things that fall into play here. It's, what does the word need mean? Okay, because everybody could benefit from supports, right? It's kind of the difference when I talked about capital D and small d, disability versus diagnosis. This is kind of like capital N and small n. It would be nice to have all kinds of supports, that's capital N, but who needs it? What is required? Okay. And that's when we're, kind of construing that particular term. So, then you're looking at some different elements here. What establishes the need? Is it grades? Is it achievement scores on state and standardized testing? Is it, they are doing homework for 3 hours a night, the parents providing tutoring? So looking at need is very broad. I also want to go, and before we get into the need conversations, I want to go back to some other cases that talk about adverse effect, and it kind of aligns to the need. So there's another case in your materials called the Montgomery County case. And this is a case where a student had been doing really well up until about the 5th grade. And the student then started having, issues outside of home. She was stealing, she was shoplifting. But then in the 6th grade, things really took a turn, and she began wetting her pants. She required diapers. She started having auditory hallucinations, and she was ultimately hospitalized and received various diagnoses, including bipolar disorder and schizophrenia. So after her hospitalization, she returns to school, and she received a whole bunch of supports. So class notes, she had a homework assignment that was modified. She had extended time, and the modifications to her workload was that she wouldn't be graded on things that she missed. Okay. She also was given like what we call a flash pass. Like I need to go to the office, and she was allowed to go to the office, to the health room, if she experienced auditory hallucinations and needed a safe place to go. So at the time, she was referred to special education, and the team found that she had, average academic achievement, and they focused on whether or not she had emotional disturbance, and decided she did not, because the condition didn't adversely affect her educational performance, and she did not need special education. Okay, so this is where it ties into this need conversation. So the family, just like the last case, didn't agree with that, and they sued. And at the first level, the hearing officer agreed with the parents. The district then took it to the next level, and the court at that point also agreed with the parents. And the court now is looking at adverse effect, and they said, hey, listen, the grades, would have been adversely affected had you not had that modification that the school wasn't going to grade things that weren't completed. So if the school had counted all of her missed assignments, there would have been an adverse effect. The court also noted that the student had difficulty staying focused, that she missed school because of continuing psychotic episodes. And they said that, because she kept missing school, that would be a factor in finding an adverse effect. And then when they turned to the conversation about what was the need for special education, the court rejected the school district's argument that the student only needed mental health services. And they argued that, that's a related service and not specialized instruction. The court did not buy that argument. In fact, the court concluded that the child actually needed placement in a therapeutic setting, which was a lot of, very expensive, in order for her to have access to her educational programming, and that this type of placement would be considered specialized instruction. So, when you think about eligibility, you have to kind of look at these legs in tandem. When they need something often relates to what is the adverse effect. And here, the need for specialized instruction in this case was related to her inability to stay in class, or inability to come to school. There's another case in your material called Ashley, where the court found that the child was not eligible despite getting significant supports. So in this particular situation, this also ties to need. The child was referred into special education in the 3rd grade for a suspected speech language impairment or learning disability. And the school district did not find the child to be eligible. But then about 9 months later, the family referred for consideration of other things, cognitive disability, other health impaired, and speech specific learning disability. The child did have a diagnosis of ADHD, and she was performing at or close to grade level in all areas with the assistance of what they call differentiated instructional supports in the regular education classroom. Those things included working one-on-one, or working, with the teacher in the classroom, extended time for tests, preferential seating that was close to the teacher, having the test directions read. And, when the student received all of those supports, they were meeting or approaching proficiency in all of the relevant areas identified by the state's content standards. So the hearing officer determined that the student's ADHD did not adversely affect her educational performance, and the family then submitted an appeal to court. And the court then looked at these two elements, the adverse effect and need. And so the family argued that the child met the criteria if ADHD had any negative impact. So again, didn't require it to be significant. That's what the family was arguing. But the court said, listen, having such a low standard would have resulted in eligibility because there was some testimony that there was a small negative impact on the child's performance. The court agreed with the school district, and then, as sometimes courts do, they pulled the dictionary off the shelf and looked up the definition of adverse, and that the definition said adverse means to cause harm, and said, listen, when a student is able to function at an average level in a regular education classroom and experiences only a slight impact on their educational performance, it cannot be said that the student has suffered some harm. And in that case, the court clearly understood the system of what they call differentiated instructional supports was something different than special education, since differentiated instruction was available to all kids in the classroom and was not an accommodation or a different method of teaching. So this is really when we get into this conversation about need, we think about this element is there's two things to consider. Is it nice or is it necessary? And is it special? Is it something that should be a good part of good teaching? Or is it an adaptation in the content, methodology, or delivery of instruction? If we're inching into that, now we've got special education, and you have to determine, is there a need for special education? So a lot of times people, I'm sure Katy talked about this, we don't do RTI in an effort to defer we're not allowed to do RTI and say, okay, we're going to do that for a couple months, and then we'll consider whether we should do an evaluation. No, you should probably do it concurrently. So if student has never received, supports that would constitute and be able to look at the response to regular education interventions, you should be doing that in your 60 days of conducting your evaluation. Because if you do that, and then you get to your eligibility determination, and you find that the student is able to benefit and only needs regular education supports, then we don't have the third leg of the three-legged stool. Okay, because the student doesn't have a need for an adaptation in the content, methodology, or delivery of instruction. That's how you get data about and to speak to the third element. The other thing I want you to be thinking about is, the relationship between the first two legs of the three-legged stool, disabling condition and adverse effect, because there are many things that occur in the universe that have an impact on the child's educational performance. Okay, like I mentioned, house was destroyed by a hurricane, parent is incarcerated, student is a victim of trauma. Those may or may not cause a disability, but it is the relationship between the disability and the adverse effect that you have to look at. So there may be factors that have an adverse effect on a child's educational performance. They're homeless, things like that. But that is not where they're not going to require specialized instruction. Okay, there's a case in your materials called the Alvin case. It's a case out of Texas where that's an example of this, where the court considered these outside factors in determining adverse effect. And in that case, the student who did have a diagnosis of ADHD was found not eligible because there was no need for special education because of a disability. So here's some facts. The student had been eligible because they had a speech language impairment. They had ultimately been exited from services, earlier in their career. And then so from 3rd grade until 7th grade, student was not eligible. But then the dreaded middle school, which is what I'm experiencing every day, the dreaded middle school. So the student is in 7th grade and the student began exhibiting behavior problems. So they were hitting, they were throwing pencils, they were using obscene language in school, but the student was passing all of their courses. They met standards on statewide tests, all of the things. What was happening at home was significant. The student's brother died. The student was having a very strained relationship with a stepfather, and the student was having some substance abuse problems. So in the 8th grade, the student was placed in an at-risk program. He had good attendance. He still had disruptive behaviors. He had some theft, an incident of theft, which resulted in his expulsion from school. But again, the student continued to earn acceptable grades, continued to meet standards on statewide testing. So the parents referred to the student for special education, and following the evaluation, the team determined that the student was not eligible, and the parents disagreed. They took this further, and the school district, the hearing officer agreed with the parents. The school district then appealed, went to the next level, and the court again agreed with the school. The court then agreed with the school district. So the court here focused on this element. What is the need for special education? And found that the need is not determined solely by how the child is doing in the regular education classroom, but also how the child is doing looking at broader concepts, including behavioral and social progress. Okay. The court recognized that the child demonstrated academic success and they did not need special education despite their behavioral issues, since he was achieving social success as well at a school. So looking beyond what is the adverse effect and educational performance beyond just academics. But here's when we talked about what is the relationship between the disability and the adverse effect. The court reasoned that the student's behavioral problems were not because of the child's ADHD. They were the result of causes that was unrelated to the child's disability, like his brother's death and his own emerging alcohol abuse. So know that all of these 3 legs are interrelated, and you have to consider, and once we get to need for special education, does the need for special education result from the adverse effect that was caused by the disabling condition? So again, interrelated, all of those things are interrelated. I see I have some questions, so I will just pause. Okay. For students who've been placed parentally at non-public schools, how can we determine if we suspect a disability in order to determine, as the public school district, whether or not an evaluation is warranted if the non-public school has not implemented interventions to address any skill deficit? What should we be using as the basis for our decision as to whether or not we suspect? So when a student is parentally placed at a non-public school, you need to get in there. You need to conduct observations. You need to interview individuals who are educating that student. You need to do record review. You need to do all of the things to be able to make eligibility determinations. I get it that that's not easy to do because some people don't allow that type of information, but in any event, it is there's school district's responsibility to collect as much data as necessary. If not, you can always go through the evaluation process and do assessments. That's the only other option that you have to gathering information, but the information from teachers is critically important. Please, which case are you describing now regarding the middle schooler and need? I've talked about a couple of different cases in your materials. The one that I just talked about from Texas is the Alvin case from Texas. Alvin Independent School District versus AD. All right. Moving on. See where I am in my notes, because I sometimes get ahead of myself. All right. So when you're thinking about this need conversation, let's go back to the last slide because I want to touch on something here. When you're determining the need, can you really determine need without considering, what is happening outside of school. You often get that, well, the student would look really bad if I wasn't giving them tutoring after school every day. You know, what about those parentally provided supports? You know, and then the other thing when you're thinking about need is, you know, at what point does the child's performance have to fall before a need can be found? Do you have to wait for failure? You know, if you're going to look at the child's educational performance, do you have to evaluate that without the regular ed supports that the child might be getting, like that tutoring that the parent is providing? So usually the kind of performance that demonstrates a need, passing grades, usually you're going to think that that's the floor. You know, above average performance, probably not going to have a need. Average performance, you know, there's going to be opinions that differ. Below average performance, but passing, again, we've got more of a gray area. And then, you know, questioning what area must the need arise? Is it general educational performance or the specific areas that are adversely affected by the disability? So, you know, these are the things that you got to tease out. And then, you know, whether a child requires special education to do well at school or to benefit from school really presents a different question from whether the child requires special education to benefit from those areas of educational performance that are adversely affected by the disability. Again, creating that alignment between these three-legged stool. So now when we get into what is special education, that's our next slide. Special education is, you know, specially designed instruction. This is where you have to get into the definition of what constitutes specially designed instruction. So specially designed instruction means adapting to the needs of the eligible child as appropriate, the content, methodology, or delivery of instruction to address the unique needs of the child that result from the disability and to ensure access to the general ed curriculum. So again, it's an adaptation in the content, methodology, or delivery of instruction that is required, remember, required, not nice, okay, it's need and not nice, to deal with, you know, to address those needs that are created from the disability so the child can access their services. Related services can qualify as specialized instruction, specially designed instruction, if the service is considered special education. And so those are things that you have to kind of dig into your operating standards to think about. I don't, in the interest of time, can get into that very deeply. But, you know, related services are pretty broad. It's a non-exhaustive list. And so related services are going to include things like mental health support and travel training and potentially parent training and transportation and orientation and mobility services and all of the things that you, psychological services, all kinds of things. So when you're evaluating what constitutes special education and the need for such special education, you have to make sure that you take that broad approach, okay? All right. Let me see what I want to. So what is special education? Some of the cases in your materials have looked at those differentiated instructional supports and found that those things are not special education. So in your materials, you've got cases where, you know, one-on-one work with a regular ed teacher is not special education. Individual attention from the regular education teacher, not special ed. Extended time, preferential seating, reading test instructions, even social skills, study skills classes, access to teacher's notes and a note buddy or a second set of books at home, options to retake a failed exam. You know, those in some cases have been determined to be regular ed accommodations and not specialized instruction. Okay, so you really have to be thinking about that as you are making your eligibility determination. You know, think about that there is language in the IDEA and in the current version of the IDEA that talks about early intervention services, right? Intervention services that are provided before eligibility attaches, and they permit school districts to divert 15% of their funds to provide services before students are identified. I guess that is showing that there is an intention to make sure that students who are currently disabled in an area that is educationally related are defined as students with disabilities, not those students who really just need additional good teaching or differentiated instructional supports. That's not going to be considered to be special education. Now, I get it. I live in the real world. I understand that teachers sometimes don't believe that they are responsible for or have the ability to provide some of those things, and that those things need to be in this far off land that's called special education. But I'm just letting you know that that is not really supported by the legal authority. All right. Just some examples of cases in your materials where this is talked about. So there's a case called JAFES, J-A-F-E-S-S, that talks about regular education supports and kind of the differences in there. So there's one there. If you want to dig into it, you can see. Let's see. Well, where do the courts draw the line? Meaning, what is special education? So some key elements are including whether the modifications, including behavior plans, are available to all regular education students, and whether they represent an expectation that I'm sorry, this keeps going off and it's very loud. Whether they represent just kind of good teaching, an expectation of teachers. So once the modifications become significant and they alter the curriculum in some way, or they alter how the curriculum is delivered, that's going to look more like specially designed instruction. So when a child is actually learning something different, a different skill than their peers, if a modification is merely allowing the child to access instruction and demonstrate their learning in a different way, that may not be specialized instruction. So you're really looking at something that's more than a minor modification to the content, methodology, or delivery of instruction. So good teaching requires an adjustment to instruction to meet the varying and individual needs of students. So children should not be identified as disabled if they only need that kind of differentiated instruction, because ultimately, if special education is the only place that students are going to receive that kind of support, it's no wonder why eligibility would ultimately be so attractive. All right, our next slide is about specific procedures for learning disabilities, and we don't have time to go into that because it's pretty extensive, but your materials are pretty comprehensive for the determining eligibility for specific learning disabilities. So I'm going to skip past that. And we do have a scenario, which we're also going to skip because we don't have enough time to talk about it. Instead, I would like to open the floor. I know you guys have been pretty engaged, and so I would like to open the floor in our limited time that we have available for additional questions. Now, you can't not have questions now. Come on. We've exploded your brain.
Laura, I did give a spoiler at the beginning that you might be reading some poetry.
Yes, I do have a poem. I will read some poetry.
I have a question, if I could ask.
Sure.
I wanted to make sure that I was hearing you correctly earlier, or it might have been Katy, that said that if the school psychologist is a member of the ETR team and had evaluated the child doing cognitive or some other, if she meets the qualifications also as a district rep, she can do both?
Mm-hmm. Yep.
Okay. Because our SST has been telling us for the past couple of years, and every school district in Southern Ohio that I know of changed it to where there are now 2 people there, because we understood it to be that our district rep could not be the school psychologist.
Well, I mean, you have to go back to what is I got to call my operating standards. You got to go back to what is the definition of the district rep and really take a look at, does the school psychologist actually meet the definition of the district rep? And I would submit to you that they may not.
It's page 120, Laura, I think.
Oh, thank you.
Maybe supervision is the question that they gave as to why they might not qualify as a district rep.
Well, they have to be not only qualified to provide or supervise the provision of specially designed instruction, they also have to have the authority to be able to commit the resources of the school district. So the district rep and it is not on page 121 of mine, but the district rep has very, they have to be able to be the person in the room who says, yes, that can happen. So if you're sitting at an IEP team meeting and the parent says, you know, I would like to have private placement, and the team believes, yeah, that's going to be appropriate, the district rep has to be able to commit the resources of the district. And I find most of the time that the school psychologist does not have the authority to either supervise the provision of specially designed instruction or have the ability to commit the resources of the school district. And that may be, Pam, where you, if it was Pam, I think, that may be where people have backed away from having the school psychologist be the district rep. Okay.
Thank you. That makes it clear.
Our SST and OEC has advised us that no one on the IEP team can serve multiple roles, even if they meet the criteria of multiple roles. Okay, so the operating standards, I don't know where this is coming from OEC. The operating standards do say that they can meet more than one criteria. The problem is they usually don't meet the criteria. And just like I had said, when we were looking at, can the regular ed teacher also be the same as the special ed teacher? That's only a little bit of the definition. It is special education teacher of the child and regular education teacher of the child. That is the entirety of the definition. And they're not, and it's likely that people are not going to meet multiple roles if they're just a regular education teacher or somebody who has regular or special education certification. So I don't know, I can't speak to what OEC has said on that, but I would venture a guess that it is likely that they don't actually meet the definition. So hopefully that answered that question. All right, there was one more. Oh, that was the question. Okay. And in 2 minutes, I will read some poetry. So for those of you who know that I have twisted brain and sometimes I write poetry related to special education. And so here is my poem on special ed eligibility, which is called To Be or Not to Be, the special ed version. Could I please answer the question from Deb Emmond, please? I don't see a question. Oh, who can deliver specially designed instruction? For instance, can a reading specialist deliver specially designed instruction for a reading goal? Can a general education teacher? Well, it depends. You know, what is the specially designed instruction? Who is qualified to teach that? You're going to get people who are going to say, well, it needs to be an Orton Gillingham certified level 2 practitioner, you know, and the question becomes, does it need to be? It might not. So if it's specially designed instruction, you know, can the specially designed instruction be delivered by a general education teacher? There isn't one size fits all related to that. It is the IEP team that determines who can provide an adaptation in the content, methodology, or delivery of instruction. So there isn't a one size fits all, but I would expect that if somebody who has a reading endorsement is delivering a specialized program for let's say a different methodology, let's say you're using a particular methodology in your district and somebody needs Linda Mood Bell. And this person is a regular education teacher, but they have had training in delivering Linda Mood Bell. Can they deliver that specialized instruction reading? Probably. You know, so I get again, sorry, it's the lawyer answer, but it's going to depend. All right. All right, so my poem is To Be or Not to Be. That is the question of eligibility. To Shakespeare, I offer my apology for this attempted special ed soliloquy. The question of a student's disability is answered by completing an MFE, which determines the need for an IEP and the student's entitlement to FAPE. It starts with something called Child Find, and then there's a plan for assessment that's designed. You ask for consent and hope it's not declined, then 60 days later, the evaluators opined. Is it a language deficit or deficiency of mind? A child with autism or one who's deaf or blind? Emotionally disturbed or wheelchair confined or learning disabled and now falling behind? Disabling condition and adverse effect, need for specialized instruction in any subject. Which category does the team suspect after looking at the data it took time to collect? The decision is made. Will everyone agree? Or if not, will the parent want an IEE to find that they have a child with a disability who is entitled to receive an FAPE? So when you ask the question to be or not to be, or question a student's eligibility, I hope you will remember this bit of levity from wannabe poet Laura Anthony. The end. Sorry we kept you 2 minutes, but really do appreciate all of the questions. We appreciate your guys' interest in coming to the ESELA program. As probably was described at the very beginning, this is something that we have been doing for many, many years. And we are continually surprised at the number of people who are joining for this type of refresher for those who are experienced, as well as for new information for those who are entering into the world of special ed administration. So our next couple of sessions are going to be, you're going to see different people on the Bricker and Eckler special education team, including Katy, Melissa Bondi, myself, Erin Heydrich, and Susan Gary. So hopefully you'll have as much engagement on those sessions as you guys did today. I would like to thank the SST. I'd love to thank the wonderful sign language interpreters who I've just been super impressed by, and I keep watching you guys and I love it. And I also really appreciate everybody's questions, because I will say, sometimes when people are going to different audiences, like you're sitting in a concert, you're like, this has been the best audience, Columbus, right? You guys have been really great. And so we really do appreciate the engagement, because we know that you're actually listening and you are interacting with us. So thank you so much.
Thank you.
Thank you all. And just remember, if you can fill out that survey as well as register for the other upcoming sessions, that way we can get a track of who is coming, and that way you will be accounted for on the certificate side of things at the end. We hope you all have a great day and a great weekend. And thank you again to Katy and Laura for the information today.